Planning permission and permitted development are two ways of either extending or changing the use of existing buildings. But which one is the best for property investors and small-scale developers to focus on? Permitted development or planning permission? Stay tuned and I'll share with you exactly where savvy property investors are focusing their energies. Hi, my name is Ranjan Bhattacharya. I've been investing and developing properties for the last 30 years. You may have seen me on the hit Sky TV show Property Elevator or attended one of our Central London property investor meetups. So if you're new to this channel, make sure you subscribe and hit that bell icon. We put out new content every week. Also smash that like button. It means more people like you will see this video. So today we're going to talk about the planning system, and let's face it, the planning system in the UK is broken. It's unfit for purpose and it works against small-time developers. Here's an interesting statistic for you. 30 years ago, 40% of all new dwellings that were created in the UK were done so by small and medium-sized property developers. Today, that number is less than 12%. That's less than 12% of new dwellings are created by small and medium developers. Why is this? Well, for small and medium-sized developers, the planning system works pretty much like this.
Computer says no.
When you submit a planning application to your local authority, who do you submit it to? You normally submit it to the Development Control Department. A clue to their attitude and their mindset is really in the name of their department. It's development control. That's what they want. I always remember a time in my own career where we put in 2 applications for 2 flat conversions on the opposite side of the same street in London. So exactly the same houses, opposite side of the same road. We submitted planning applications to convert both of these houses into multiple flats. And it was exactly the same scheme in both buildings. They were submitted in the same week. One got to one planning case officer and one application went to another planning case officer in the same council. One got rejected, one got passed. Now go figure out the rhyme or reason for that. Now that really underlines the uncertainty of the planning process, the planning applications process for property developers. Now, when you actually look at statistics, by the way, they will actually tell you that vast majority of planning applications actually go through first time. And simple household applications to put up a garden wall or something like that, for a house, or do a conservatory at the back or something like that. Those sort of things relatively go through smoothly. And those account for the majority of the planning applications the local authority receives. But the issues are always where property developers and property investors want to create extra dwellings. Those are the applications that seem to meet with most resistance. The system is meant to be that when you submit a planning application, you get an answer within 8 weeks. But these deadlines are frequently not adhered to. It can take 8 weeks. If you're lucky, it can take 6 months. It can take 2 years or not at all. Your only recourse is to put in an appeal with the Secretary of State. And that can take 8-9 months or more. Of course, along the way, your planning officer will make you jump through dozens of hoops with extra specialist reports on this, that and the other, which will cost you £1,000 a pop. And then when you get the permission, there will usually be a whole bunch of conditions attached to it, often that runs into pages, which have to be discharged before building works commence. So what this means is that if you're submitting a planning application to get some work done or build a scheme of flats and what have you, it can take years before you put spade in the ground and actually start works. The problem is, of course, is how do you fund that period of uncertainty? How do you know whether it's going to take 8 weeks or 2 years or more to get that planning permission through? Big developers with big pockets, they can actually fund that level of uncertainty and land bank to a certain extent. It's the smaller scale developers that simply can't afford to do that, and that's what's driven smaller developers out of the market. So what have your experiences of the planning system been? Let me know your planning permission disaster stories in the comments below. And smash that like button as well. It means more people will get to see this video. The government, of course, recognises this. The government fully recognises the problems and blockages that local authorities put up to stop small-scale developers. And that's why they've introduced something called permitted development rights. Permitted development rights are national. When I say national, I mean England, folks. Unfortunately, permitted development rights that I'm talking about apply to England, not in Scotland and Wales. Blame devolved government for that. So permitted development rights allow you to do certain things to buildings with really light touch planning permission. In other words, it brings to small developers much more certainty to the planning process. One of the great things about permitted development is that you have to submit a prior approval notice to your local authority, which tells them that you're going ahead and implementing your permitted development rights. And they have 56 days to come back to you. That's it. 56 days to come back to you and tell you whether it's a goer or not. And the thing is, there are only a fixed certain amount of criteria, qualifying criteria, that they can gauge your application against. They can't take into account any onerous waffle that some councillor might have on his hobby horse for the month. They can only take into account fixed criteria. And the great thing about having that fixed criteria is if you know what they are, then you can basically self-assess whether or not your scheme is going to get prior approval under permitted development or not. And that brings certainty to the process, and it brings smaller developers back into the game. And now, of course, there's so many opportunities for permitted development because the government have introduced a whole swathe of new permitted development rights which come into force August the 1st, 2021. We'll get back to the video in just a moment, but what I wanted to really tell you about was what is the most exciting opportunity in property right now, and that is repurposing defunct commercial buildings to residential use. Now, most people don't really know where to start, what to look for, and how to exploit these opportunities, and that's why I've prepared 90 minutes of free training for you to get you started on this wonderful journey. You can register for this free training at property-workshop.com. Join me on that free training, and I'll leave you to enjoy the rest of the video. Now, when you've got so much that you can do under permitted development with so much certainty, why waste your time and energies on planning permission when you've got no idea if or when you're going to get that permission passed? I've done this video here on the Class MA rights, which say specifically what you can do under permitted development to change the use of defunct commercial buildings to residential use. And there's a huge amount. So why have the government done all this? Well, let me share with you why. You see, commercial buildings, they only exist for commerce. And if the way commerce is done changes, then those buildings can become defunct. Now, previously, the types of commercial buildings that became defunct were very, very big. I mean, for example, think of all the canal-side warehouses that used to be on the canals up and down the country. Now, when the railways came in, those buildings became defunct. And a lot of those buildings have now been converted into trendy loft-style apartments and the like. You know, Camden Market, for example. Camden Market used to be stables for 10,000 horses serving London in the days of the horse and cart. When the motor car came in, that whole piece of real estate became defunct and has been repurposed. The last whole-scale repurposing of commercial buildings happened in the 1980s when whole swathes of manufacturing moved abroad and we were left with loads and loads of factories and things which didn't have a use. These were, of course, repurposed to residential use. But the thing about all these commercial spaces in the past is they were massive. They were 10,000, 20,000 square foot. So those sort of buildings naturally lended themselves to larger developers, well-capitalized developers who came in and repurposed those buildings into flats. Now what's happening is the type of buildings, the type of commercial buildings that need repurposing are a lot smaller. You know, they're things like a local Santander bank branch, which is just a ground floor and a couple of uppers. You've got a William Hill betting shop, which is shutting down. You know, you've got a small office building. Now, these sort of buildings are just too small to entice the larger, big-scale house developers. They're interested in building 70, 80 units plus on one site. So they are just simply not interested in these small sites. So who is going to repurpose these buildings? When we've got a massive housing shortage in the UK, we're only producing about 100,000 dwellings every year when there's a requirement for 300,000 dwellings every year. When the country needs so many dwellings, does it make any sense to have these smaller commercial buildings languishing in no man's land because no one wants them as commercial buildings, and yet it is a treacle process getting their use changed through the conventional planning system. So that's why the government have done it. And the further thing I'd add is this. In the property business, I've been doing property now for 30 years, and every 6-7 years you tend to reset your sails, if you like, on your property journey as the wind blows in different directions. And the wind does change in different directions. For example, in recent years, standard buy-to-let has got a little bit more complicated. We've had things like Section 24 tax on mortgage interest, and I've done some videos on how you can deal with that problem up here. And also, of course, there's increasing legislation for buy-to-let landlords, increasing costs of regulatory compliance, things like mandatory HMO licensing schemes coming in up and down the country. So it seems like the wind is blowing against the buy-to-let landlord. So what I like to do is to figure out which direction is the wind blowing. Set your sails accordingly so that you benefit from that wind blowing in your direction. The wind is definitely blowing in the direction of encouraging small-scale property developers. And that's because, one, there's an abundance of commercial buildings which are ripe for repurposing right now, thanks to COVID-19 accelerating a process that was happening naturally in terms of change of working practices, which means that offices and shops are now in massive oversupply here in the UK. You've also got these permitted development rights which are coming in this summer, which allow you to repurpose these buildings with only light touch planning permission type of process, and allow you to do so with a huge amount of certainty. And of course, with interest rates at record lows, it's relatively straightforward to finance such repurposing schemes. So what you need to get clued up on is what buildings you can change the use of under light touch planning permission, in other words, permitted development, and what buildings you can't. A lot of people say to me time and time again, I've seen this pub for sale and I want to convert it into flats. I say, don't bother, mate. I'll tell you why, because there's no permitted development rights for pubs. Pubs can be a long and convoluted process in order to get a planning permission through for their change of use. But instead, things like dentist surgeries and doctors' practices and former bank buildings and estate agent offices, these are good to go. These come under the new light touch planning system, or permitted development rights, Class MA as they're officially known as. And you can get these permissions through with the minimum of interference from your local authority. Now, of course, there's a lot to this, and that's why I'm running a whole series of live 90-minute masterclasses on what you can do with these permitted development rights and how you can take full advantage of these as a small-scale developer. So if you want to register for that, you can do so. The link is here on the screen, and join me on my live masterclass. We'll spend 90 minutes going through exactly what these opportunities are and how you can get on board. See you guys in the next video.